age 80 and older will triple in the next 30 years. Currently, approximately 18 to 20% of all residents in Alaska are 60 and older. Normally, the Caregiver Education Series is held at the Juneau Library. However, due to COVID, we have adapted to an online format. A benefit to hosting the education series online is the opportunity for all Southeast Alaskans to attend. So to everyone from Ketchikan to Skagway, I would like to extend a special welcome. For the next 2 Wednesdays, you will have the opportunity to hear from experts whose careers have been devoting to helping and caring for our most precious population, our seniors. These experts will address the issues and challenges facing caregivers and elders in Southeast Alaska. Today's speaker is Beth Chapman. Beth is an attorney at Faulkner Banfield. Beth has practiced law in Juneau for over 30 years. Beth specializes in estate planning, probate, trust law, elder law, and business planning. Beth is a current member and past co-chair of the Alaska Bar Association's Probate and Estate Planning section, and a member of the American Bar Association Real Property and Probate section. Beth participates in the Alaska Pro Bono program, providing legal assistance to low-income Alaskans. Beth received her BA from St. Michael's College and her JD from the University Oregon School of Law. When not working, Beth enjoys hiking, fishing, and traveling with her family. So welcome, Beth.
Thank you. Well, thank you everybody for joining us today. And I have been asked to talk about sort of legal documents or legal planning for family caregivers. And everything I'm going to say today is going to be relevant not only as to a person who is a caregiver when needing to make decisions on behalf of the individual they're caring for, but also for their own personal use. So it's kind of a dual talk, and so I think you'll benefit from it in both ways. And I want to go ahead and share my screen. So give me one moment, and you should have. There we go. You should have Planning for Disability Essential Legal Documents on your screen, I hope.
We do. Thank you.
Thank you. I appreciate that. Okay, so what we're going to do is kind of go through this PowerPoint and maybe hold questions for the end. So if you have a question, you can put it in the question and answers or the chat box. And let's see here. Why is this not moving? There we go. So what we're going to talk about is estate planning. What is estate planning? And you'll hear that term. So I really want to talk about it. It's for everybody, regardless of your level of wealth. Really what we're focused on is making sure that we have legal documents in place to designate others to make your decisions when you are unable to do so. And if you're a caregiver, you need to make sure that you have legal authority if in fact you are needing to make financial or healthcare decisions for the individual for whom you're providing care. We'll also talk about how assets are going to be distributed. Estate planning is simply a way of saying, have your will done, a revocable trust, or possibly even beneficiary designations. We also use estate planning as a generic term for special needs planning. That is making sure that we are protecting the beneficiaries, whether we're dealing with minor children, persons with disabilities, and in particular, people who may be receiving Medicaid. So that is one of the things you always want to be considering when you are working with these documents, either drafting them for yourself or implementing them for the person for whom you are giving care. And we also do a lot of long-term care planning under the guise of estate planning. That topic is well beyond the scope of today's presentation, however. So what are our essential documents? We really talk about having, I used to say 3, but really in reality 4 categories of documents. And the first is a durable power of attorney. We're going to talk about that. What is it? How is it used? How is it created? The Advanced Healthcare Directive, again, how do we put one in place? What are the limitations of such a document? We'll touch upon how we are going to dispose of assets at death under two different categories, the will or a living trust, which is two of the very typical types of estate planning documents that are used. But I'm also going to talk about transfer on death provisions, because we see these more and more as people are able to get onto the internet, fill out their beneficiary designations on their IRAs, and possibly even create transfer on death deeds. So it's important we talk about all of this, because at the end of the day, we need to make sure everything is coordinated to protect our beneficiaries, protect the assets going to the individuals we want them to go to. So first thing we're going to talk about, powers of attorney and advanced healthcare directive. Of all of these documents, these two are the most essential. And of these, the absolute most essential one is the power of attorney. You will hear this described as what's called a durable power of attorney, a general power of attorney, or possibly even a limited power of attorney. All of those are just terms to say, this is a document under which one person is giving another person the authority to make their decisions while they are alive. And it can be limited as to the types of decisions. It can be limited to the length of when this power is going to be effective. And it can also be durable, meaning even if you become incapacitated, that power of attorney will continue beyond the period of incapacity. That is very, very important. So when we're working with elders, and not just elders, but almost everybody, we really want to look at having durable powers of attorney, because we need those in place in the event somebody needs help, because without them, we may need to go to court to get that authority. So durable just means it will go beyond disability. And under Alaska law, if you sign a general power of attorney or any power of attorney, and you do not say that it is going to go beyond disability on a determination that somebody is incapacitated, that's two doctors certifying incapacity, that power of attorney is automatically revoked. So durable is the key. And I'll say it here, these forms are available from Alaska Legal Services. At the end of this presentation, I do have their website listed, AlaskaLawHelp.org, and great information in there, and the documents are in there, including that box that says, this is durable and will continue beyond my determination of incapacity. So if you're a caregiver and you're looking at one of these documents, is this durable? Do you still have authority to act, assuming you're the agent, or does the agent who is nominated have that authority if the person for who you are providing care is incapacitated? If it doesn't say that, that person no longer has legal authority. So powers of attorney, durable powers of attorney, are used to delegate financial matters. Advanced healthcare directives are delegating authority for healthcare decisions. These documents are really important because it allows you to make, whoever's signing the document, to make the decisions on who's going to help. You can have one person, you can have two people, it doesn't matter, 3 people. Don't go beyond that, it gets a little too complex. But it really is designed that you're in charge, you're making the decisions of who's going to help you, and it can really avoid conflicts among family members if there is an incident where somebody is incapacitated. And again, to reiterate, without this document, no one can control your property. So if you are married and you have a retirement account in your name alone, always has to be in your name alone, your spouse cannot access your retirement account. If you have a joint account, clearly they can, because they're a joint owner. But if it's something is in your name alone, or is in the person for whom you're providing care, there's no authority to access that, even if you are married. And so durable power of attorney, if not, guardianship and conservatorship in the court system when somebody needs assistance making decisions. So our durable power of attorney, as I mentioned, can be very broad. If you were to look at the form, there's a whole list of powers that are delegated. Those used to be automatically delegated when you signed the document, but now you have to go in and check the ones you want. And be careful that you don't limit your authorities if this really is designed to take the place of the decision-making of the person who needs assistance. Because if you limit it, you may end up in a circumstance where you no longer have the authority you think you have. So it's now an affirmative check that needs to be done in this form. The second page of the Alaska statutory form also has made some other specific powers that you have to say you're going to grant. And those powers are gifting powers, the power to create trust, the power to make beneficiary designation changes, change rights of survivorship, and a few others. When we're looking at durable powers of attorney and we're working on a plan to make sure we have a smooth transition when somebody becomes incapacitated, we need to make sure we have granted the right powers. Gifting powers can be very useful when we are needing to do long-term care planning for Medicaid. Creating a trust. Anybody who's ever had to deal with Medicaid knows many times we have to create what are known as Miller trusts or income-only trusts. If I have a power of attorney for a person for whom I have to create such a trust, and they did not grant their agent that power, I'm going to have to go to court on behalf of the incapacitated person to get that trust approved by the judge. We want to try to avoid those things. Are there limitations on these powers? Yes. In the statute, the agent is limited to exercising these powers consistent with the person's best interest and consistent with what their will or estate plan may already say. So we always talk about, if I have a will for somebody that says I'm going to leave it to my 2 children, and I have an agent under a power of attorney say, well, I'm going to make a gift to a charity to protect it, assuming that's what they think is appropriate, we're going to say, no, you can't do that because that's not consistent with the overall estate plan. So you can see how these all become intertwined, and we have to be careful. Making sure, again, it's effective on disability. So that durable power of attorney is extremely broad. When you are acting as an agent, whether you're the caregiver or somebody else is the agent, they always need to look out and be making all decisions in the best interest of the individual for who they're making decisions. They cannot consider their own interests at all. They're what's known as a fiduciary under the law, which is the highest standard we have under the law. And you must always act solely in the best interest of the person for who you are making the decision. Even if you have such a document and that person is able to participate in making that decision, they may just need assistance. You have to bring them into the decision-making process. You're not overriding them. You're there to work with them and to have them participate as much as they can on a meaningful basis. Durable powers of attorney for financial matter are notarized documents. They're not witnessed. They just need to be notarized. And they can be such that they're only effective when there's a determination of incapacity, or they can be effective as soon as they're signed. And we generally recommend having them be effective as soon as they're signed because it makes it easier for the family to transition to using that document when the time comes to access a bank account or possibly an IRA. From experience, we know if you try to access an IRA at a brokerage firm such as Fidelity, they may not accept it without affidavits from 2 physicians, and they still might not accept it. If it's effective on signature, there's no question, and they're more likely to allow you to proceed and avoid the need to go to court. So the second document I want to touch upon is the Advanced Healthcare Directive. Again, that's a document you're delegating authority to somebody else to make those decisions. If you are the person who has that authority, always are making these decisions, looking at what's in the best interest of the person who gave you the authority. We call them the principal. That you have to not only look at their best interests, but what are their belief systems? Do they have religious restrictions under their religious beliefs on, for example, receiving blood transfusions? Do they have specific beliefs about end of life care? There's a whole variety, or receiving opiates. Whatever the question might be, you need to be looking at their whole person, their whole life, and say, what is it that they would really want based on the information you have about them, and make the decision accordingly. So your advanced healthcare directive does two things. It names your agent for healthcare decision-making when you need help. Again, effective on signature or effective on disability, that's a personal decision. Not as critical for it to be effective on signature because we're working with the physicians and the hospitals, and they can assess the incapacity and the need for the person to step in. If it's effective on disability, we still have that affidavits from two physicians to activate it. The other thing that it does is it gives you the ability to leave end-of-life directives. And end-of-life directives in an advanced healthcare directive are that. They're just directives. They're your wishes. And while we have a statutory form, you are free to go beyond that. So a lot of people use what is known as the 5 Wishes program, and they may attach it and say, here are my other wishes beyond what is listed under the statutory form. The end of life can be in a separate document or in your advanced healthcare directive. It's generally easier to have them together because everything's in one place. These documents not only need to be either notarized or they need to have 2 witnesses. But those witnesses are pretty limited, and I have it listed here as to who can be a witness. Not family members, not the person who's appointed as an agent, and nobody in your healthcare provider or healthcare facility. So advanced healthcare directives under the statutory form are really focused on what are your wishes for withholding of life-sustaining measures if the doctors determine you are no longer going to either have meaningful life to a high degree of certainty. If you are brain dead, for example, will they withhold life-sustaining measures? What is your wish about that? Do you want it or do you not want it? And it will also look at what if you have a terminal condition. And if the doctors determine that there's no hope for recovery, then, and if it's your wish that you do not want life-sustaining measures, you're giving instructions to your family, to your agent, and to your doctor to go to the next step, which is to actually issue a do not resuscitate order. The advanced healthcare directive can also talk about the withholding of nutrition and hydration. That is artificial nutrition and hydration. That is, you're asking in those same circumstances where the doctors determine there's no hope for recovery, you're not going to get better, that you do not want to be kept alive solely by having a gastric tube or other means of providing you artificial nutrition and hydration. And again, can have a lot more detailed instructions. I should say the third thing this document does is it does have the ability to be an organ donor on it. If it's not on your driver's license, you could still be an organ donor by completing the form. Also, we do not provide this, we do not discuss this with our clients, but there is a section on authorizing mental health treatments. Anybody who's interested in wanting to fill that part of that form out, we do direct them to their healthcare provider because it's a very intrusive procedures that you would be authorizing. So, excuse me, I went too far here and I'd go back, but I'm not sure how to do that. So the other part of it is, I want to stress that an advanced healthcare directive is not a do not resuscitate order. Those are issued by physicians. And for somebody who is possibly needing to go to hospice or wants to be going to hospice, they can actually go into what is known as the Comfort One program, which is the state protocols for do not resuscitate orders. All of that is done through the physician and not through the advanced healthcare directive. The advanced healthcare directive, just your directions to your agent to say, hey, I don't want these do not resuscitate orders to have that meaningful conversation with the physician who would then issue the do not resuscitate order. So those two documents are extremely important. Just to reiterate, for financial matters, if you do not have a durable power of attorney and somebody needs to access your financial accounts in your name alone, they can't do it, period. There are no exceptions to that. There's no marriage exception, nothing. In that case, we end up needing to get a conservator appointed through the court system, which is an individual who oversees the money of an incapacitated person. For healthcare directives, it's a slightly different rule. If you do not have an agent appointed for healthcare decisions, it is possible that a family member, a spouse, a child, and another adult person could, in fact, step in and make those decisions for you. That's called our surrogate law. So we may not need to go get a guardianship in that case, because if the hospital will recognize the surrogate law in the absence of a healthcare agent, that's okay. One thing to be aware of, if you have to go to the guardianship route, our statute prohibits a guardian from authorizing the removal of life-sustaining measures. They are not allowed to say, do not start life-sustaining measures. They are not allowed to say, issue a do not resuscitate order. We are working on trying to modernize that statute a little bit to allow some authorization of that. And instead, what it says is that they don't have to object to the withholding of it. So if the doctor says, I'm going to remove a ventilator because this individual is going to die regardless of what we do, the guardian doesn't have to step in and object to that, but they can't authorize it, making that healthcare power of attorney very important, because they would have the authority, if you say, to go ahead and make those decisions for you. The other document I want to touch on really quickly is the supported decision-making statute. This is relatively new. We have never done one in our office, but these are really designed to allow somebody who really wants to have somebody help support them make decisions. They don't want to have an agent under a power of attorney yet. Maybe they want to have that when there's a determination of complete incapacity, but they need help. So it's somebody who is really capable of making decisions, but maybe not fully. And they are allowed to appoint supporters. They cannot be paid caregivers unless they're families, because family members can be paid caregivers, of course. And there's a few other limitations. And this document is really going to list the type of assistance that this person is going to be able to help, authorize them to get to medical records, attend medical appointments, whatever it is, would be allowed. And this is really important because even somebody who's got a guardianship, even if you have a power of attorney, you can still have this document. What's important, though, is if you have a guardianship, somebody's under a guardianship, they still may have capacity to sign a supported decision-making and have somebody else still helping them. So this is really designed to give a little bit more control to people who may be under guardianships, but are still capable of making some of their own decisions, sort of an in-between document. And that's why we haven't used them, because we haven't found the right circumstance under which it would really be applicable. So I talked a little bit about guardianships and conservatorships. Really important as a caregiver to know that this option exists. Even if there is a power of attorney, but if a family member has a dispute with the agent, doesn't feel that the agent under that power of attorney is acting in the best interest of the family member, then guardianships and conservatorships are available. Guardianships are the procedure to get appointed to make all decisions except for financial decisions. But if somebody is a guardian with full guardianship of powers, they are also the conservator with the authority to make financial decisions. Sometimes we only need a conservator. We only need somebody to step in and help with financial matters. Sometimes we only need a guardian. because we might have a trust or a really good power of attorney for financial matters, but we don't have a power of attorney for healthcare. So it can be split up, it can be one and the same person. It is a little bit more of an intrusive procedure. It's a court proceeding. Petitions are filed with the court. It's deemed adversary, so that the person for whom you are seeking a guardianship is entitled to legal counsel. A court visitor is appointed by the court to come out and investigate and see what is in the best interest of the person. And the judge will determine the level of assistance needed. Our statutes are designed that we only appoint guardians and give guardians authority to the least restrictive alternatives, meaning only if it's absolutely necessary. So we can carve out powers, we can limit them. We have a variety of ways of being creative with these documents, but it is a court proceeding. There is the ability to do these on an emergency basis or just through the normal course, which takes a lot longer to get to the court system. So I mentioned the surrogates. I just had this here on my spreadsheet. So we really do like to avoid guardianships and conservatorships just because it is a lot more intrusive of somebody's personal finances, their healthcare decisions. Even though these are closed files, nobody can access them. They're closed hearings. The fact that there is a guardianship is a matter of public record. So that's just something to be aware of, why we always really focus on having powers of attorney and healthcare directives. So I'm going to completely switch gears now. And then, of course, hopefully people have questions at the end, and we'll come back and ask on all of what I've just talked about. But when you are a family caregiver, how the assets pass at death are really just not as relevant to really what you're doing, because you're just providing care. But a lot of people want to know, for themselves, how is everything going to be distributed at death? And as I mentioned, if you're an agent under a power of attorney, you really do need to know how assets are distributed when your principal dies, because you have to consider that when making decisions. So how do assets pass at death these days? So many ways that people don't coordinate these. People do it one way. They write a will that might look a little different. So my message here is, you need to know everything you own, and you need to know how it's going to pass when you die. People are surprised all the time. We're working on one right now. We thought we had all of the assets going into trust, supplemental needs trust, to protect those assets for Medicaid purposes. But hence, one asset never got transferred, never got updated by the broker. And now we are faced with somebody potentially losing Medicaid because they don't have the ability to move the money into that trust that we had protected. And they're going to have to take other steps to try to protect their Medicaid. So really important, all of this. How do we have transfer on death deeds? What the heck is that? This is a deed people can prepare while they're alive and say, when I die, my property is going to go to X. This deed must be recorded prior to the date of death, recorded with the state recorder's office, which no longer exists in Juneau. So it's all done electronically now, or mailed to Anchorage. It's completely revocable, meaning that it can be changed by either recording a revocation or just doing a new one. You can also state, can your agent under a power of attorney revoke it? It might be needed that you need to revoke one of these. So you can grant or not grant that power. And whatever, if it exists at the time somebody dies, that property is automatically going to become owned by the designated beneficiary in that deed. And if that person is somebody who may have needed, maybe on Medicaid or SSI, that can be problematic if it hadn't been properly addressed and put into a trust. So can be very useful, not used as much as we would have thought. And that's probably a good thing, because the ones we have seen have caused potential problems. we don't see them used very often, but every once in a while they may be useful. The other thing that we always talk about is, and I'm going to skip down to beneficiary designations. These are like transfer on death deeds, but these are used for IRAs. They can be used for bank IRAs, retirement, 401k. They can also be used for life insurance. If you go to a bank, they're going to be called pay on death provisions. If you go to a broker for a non-retirement account, like an investment account, they'll be called transfer on death provisions. But they all mean the same thing, that you have designated the person who's going to receive this account at your death. With any tax-deferred IRAs and retirement accounts, there's a slew of income tax considerations well beyond the scope of today, but something that always needs to be considered. And again, you want to be clear and make sure that the person who's going to be receiving it is who you really want to get it, number one. And number two, you're not going to be causing them any harm if they are, for example, at the Pioneer home or a minor child, and we want to protect it. So those are all available. We see more and more of those. And it can be very dangerous if they're not used appropriately, but can be also very beneficial and are essential for tax deferred accounts, 401ks, IRAs, PERS, SBS, all of those accounts, to ensure that we can maximize income tax deferral. Jointly owned assets, we all know what those are. You have a bank account. If you own a bank account between two spouses, they probably own it with what's called rights of survivorship. Whoever's the survivor gets it. A lot of people want to add their children to their bank accounts because they want to make it simple. But if they add that child as a joint owner, that child gets the account, which may not be what you really want. So you might have a will that says, give all of my assets to my 4 children, but for convenience, you put one child on a $100,000 bank account. That one child gets that account plus 1/4 of everything else, may not be what was intended, and can cause some acrimonious moments and some dysfunction in the family, and legal fees can be incurred unnecessarily. If what you're wanting to do is to make it easy for somebody to pay your bills, make them an authorized signer on the account, not a joint owner. We also can have real property owned joint. If you are an unmarried couple, you absolutely cannot own property joint with rights of survivorship. That's real property. Houses, vacant lands, commercial buildings, all of those, if you are not married, will need to go through probate when you die as to your ownership interest, or through a revocable trust. It cannot pass automatically to the other owner. Only married couples can own property, real property joint with rights of survivorship, or also known as tenants by the entirety. If that is not stated on the deed, but in fact the couple is married, it is going to be presumed to be tenants by the entirety and passed by rights of survivorship. And that's not always a good thing. If I have one spouse in the Pioneer home on Medicaid, I really don't think I want them getting that house by rights of survivorship. And I may be using my power of attorney to retitle that in a different way to make sure that it's going to be protected. So if we don't have transfer on death deeds, we don't have beneficiary designations, we don't have jointly owned assets, how do we know how to pass an asset when somebody dies? Well, we look to a will. The first thing we're going to do, we're going to look to see if there's a revocable trust. This is a trust that is established during life. Assets are transferred to the trust, and the person who created it can be the trustee. They can change it at any time. They can use the assets. They could take the assets out. And it's also known as a living trust, a revocable trust, and it's designed solely to avoid probate. It has no other benefit other than to avoid probate. People ask me all the time, I have a revocable trust, can I qualify for Medicaid? Are those assets protected? No. They're considered your assets for all purposes except at death. Then the trust tells us how to pass those assets. and we don't have to go to court and start what's known as a probate to get authority to access the assets and distribute them the way they're supposed to be distributed. So if we don't have a living trust and we still have assets that we need to figure out what to do with, and how do we get authority to do them, is there a will? And if there's a will, then what we do is we take that will and we look at it and we say, well, gee, what process do we need to use to get the person who is appointed the personal representative, also known as the executor? And one point to remember, if you have a power of attorney, when the principal dies, the authority is automatically revoked. So it stops at the time of death. And then we have to say, who's going to get authority now? And if we're using a will, it's going to be the person named as the personal representative. But they don't just get authority automatically. They have to go to court. And there's a variety of, there's several processes we can use. Some are more simple than others. The most common is known as an informal probate, where the will is filed with the court. The court issues what are known as letters testamentary, and off goes that personal representative to do their job, inventory the assets, notice creditors, pay the bills, and then distribute the assets and close the estate. So wills are really can be very important because we need to know how to deal with assets that we don't have any other way of passing them. But remember what I said, it's important that you don't say in the will something contrary to what you put in your beneficiary designation, because boy, will that cause some difficulties. Intestate succession, what the heck is that? If I have no beneficiary designations, no revocable trust, no will, no transfer on death deed, I know I have nothing, and I have this house owned by a decedent, who the heck's going to get it? Then I have to look at the Alaska statutes, and it's going to tell me who gets it. And typically that's a spouse, not always the spouse in full, depending on if we have blended families or not. And so that's just a little bit more complicated. Sometimes it gets us the same result, meaning it all goes to the spouse. Sometimes it doesn't get us the same result that the person might have wanted had they written a will. So that's sort of the process on how we pass assets at death. And as a caregiver, it's only important to the extent you have that authority under the agents, under the power of attorney, because you need to know to make sure that you're acting consistent with that plan on behalf of the principal when making decisions. So I went through these already. Just to reiterate, transfer on death deeds, what they do, wills, intestate succession when we don't have a will or any other way. Even with a will, people ask me still to this day, do we need to go to court? Yes. Intestate succession, do we still need to go to court? Yes. Trust, maybe not. It depends on assuming everything's done properly. Transfer on death deeds, no. One thing that's important, our court has made this process as simple as possible. And at the Alaska court website, there are all the forms, including booklets on how to do a probate. They also have booklets on how to do guardianships and conservatorships, as well as most, if not all, of the forms. So revocable trusts, I talked about. They're designed to avoid probate, not as needed if in Alaska, because we have pretty informal probate systems, can be useful and are done under certain circumstances. We talked about jointly owned assets and beneficiary designations. And this page is really focusing on additional resources. So what is out there that we can go find more information? So one of the things that's really wonderful is this organization called ACTEC. It's the American College of Trust and Estates Council, of which I am a fellow. And they have videos, and they're very short. They're 10-minute videos, and it's on every topic you can imagine under estate planning: powers of attorney, guardianships, beneficiary designations, healthcare directives, all of that information. And there's a link here. You can always just also Google actecfoundation.org and get that. It's also on our website where you can link into these documents. Really useful if you don't want to watch the video. then you can also, there is a transcript right below them. They may be on YouTube as well, but I've never looked for the YouTube link. My favorite place to send people as well is AlaskaLawHelp.org. This is a website produced by Alaska Legal Services. Even though powers of attorney and advanced healthcare directives and wills are for people even under the age of 60, you have to click on the 60+ senior link to get access to this information. And one day tell them they should change that because that information is really needed by everybody, not just seniors. They're going to have your forms for powers of attorney, a form for the advanced healthcare directive, and they also will have information on how to write a will, and they have great booklets on Medicaid and qualifying for it for long-term care costs if that's needed. I mentioned the Comfort One program. The Department of Health and Social Services website has information on that program, including forms. And our court system, as I mentioned, has the guardianships, conservatorships, and probate documents and booklets. And lastly, the supported decision-making document is available from the Department of Health and Social Services. So Alaska is a very user-friendly state. We try to get the information out to people. So if you are the caregiver and you have a question about what you can do under a power of attorney, you can go to AlaskaLawHelp.org and get a little information. If you are somebody who wants to write a power of attorney, there's the form. It's available and you can complete it. And also be aware, Alaska Legal Services does provide some services to seniors who are of limited means, and they are some amazingly good lawyers there. So I think that's about all I have. I hope it was helpful, and of course I'm available to answer questions.
Okay, wow, I think in some ways, I mean, I was just trying hard to keep up with so much information.
Sorry, Darby, I talk very fast. Somebody should have raised their hand and told me to slow down.
Yeah, actually, the stuff that was coming through the chat, we've had people say, this is great stuff. Thank you, Bev. We've got a few people. I have a couple of questions. So how much does it cost to make a will?
You know, there's really there's really no absolute answer to that question. So I hesitate to give that information, and here's why. All wills are different. So you might have somebody who comes in thinking they need a very basic will, but it turns out that their child is receiving SSI or is on Medicaid, and so we have to do trust. So the cost is going to go up. And of course, all lawyers charge differently, and I have no idea what other lawyers in Juneau charge. I really don't, because that would not be a good thing for us to all share that information. But as a general rule, we try, if we have very simple estate planning for a single person, we try to put together an entire packet of the powers of attorney, the will, help with the beneficiary designations, for under $1,500. But that doesn't mean that's what it's going to cost. and a lot of people have to worry about tax issues too. Not as many people, but the real driver sometimes though is blended families and special needs that can make that cost go up. So what we try to do is really evaluate it on an individual basis and try to tailor our costs to what that person needs.
Okay, I have one other question, but then Eileen Hosey asked a question. Are these Alaska documents, POA and AHCD, valid in other states?
Yes, so it depends, and it is going to depend a little bit on the state, but so most states have there's the U.S. Constitution, start with that, requires states to honor the laws of other states. So if you're an Alaska resident and you have to get care in Washington, yes, they are valid in Washington. They will honor them. There is a statute that has been adopted in Alaska, and other states are going to adopt it as well, where they're codifying that general principle, making it clear that these documents are going to be accepted in all jurisdictions. It's a good statute. We adopted it and we hope other states will as well. But yes, they generally we use them all over the country. If you become a resident of another state, however, we do recommend that those be updated to comply with that state's jurisdiction, because they are different. One, for example, is Washington, where I had said that our powers of attorney are effective on disability unless you state otherwise. Washington is just the opposite of us. So they're a little bit different. So you fill the forms out and they might have a different impact. So if you do move, we do recommend it. That they be updated.
I've got another question. I have a handwritten will. Is this okay?
Absolutely. So a handwritten will is valid. It's called a holographic will. And the key to these is that they can't be typed. When I mean handwritten, I mean handwritten. They need to make it clear this is your will, and you should make sure you appointed a personal representative / executor. They do not need to be witnessed. They do not need to be notarized. They do need to be signed and dated, however.
Okay. Let's see. I have somebody asking, please tell us about dementia and Alzheimer's directives.
And that's from Marcette down in Ketchikan, because she sent me an email today or yesterday. Hi, Marcette. And
That is.
It is. I know that. So I think it is, but she did email me about those, and I'm not sure what they mean when they talk about dementia and Alzheimer directives. So if what we're talking about is saying that these are that if you have Alzheimer's, you want certain actions taken, our statute is relatively limited. Okay, our advanced healthcare, unfortunately, our healthcare direct statute is limited to leaving direct. It does say you can leave other directions, right? Whether they would be considered valid, they should be, because it does say you can leave other directions. However, anything that moves towards the thought that it could be assisted suicide would be illegal in this state. And I don't know what they really mean about dementia and Alzheimer directives. That's a term that I've not heard before. So I'd be interested in getting information. I would be interested in hearing what that concept means. But I have heard lots of interesting times where people want to not be fed. They want to die because they have Alzheimer's. And so they write a directive that says, don't feed me. Well, that's not going to work. You know, that's unfortunately close to assisted suicide, right? I mean, and our state is very adamant that you cannot have that in your documents. Now, that's not the case in other states, such as Washington and California, Oregon, where they authorize those. So, and if somebody would clarify what they mean, that would be wonderful on those documents, and then maybe I can address them more.
Let's see. What do you think of how easy is it to do all of this online? To go to LegalZoom or some of these online services and just do this will yourself? You know, there's a lot of people. What would you recommend?
Well,
regarding that?
Well, given that I deal with a lot of wills, both in drafting them and also in administering them, people that have simple estates, there's no reason you can't do this yourself. I prefer handwritten wills, though, because if you make a mistake and you type the will up on LegalZoom, but you do not have two witnesses, it's invalid, period. We're not going to recognize it. If you write the will out and you handwrite and sign and date it, it's valid. Seems odd, but that's just the way the statute is currently written. I'm not somebody who thinks you shouldn't do it yourself if you can do it. But I also know that a lot of people make a lot of mistakes when they do it themselves. And the more complex it becomes, the more likely you shouldn't do it yourself, because you might make a mistake. But I think that if people want to try to do it themselves, they want to save. I like to save money. I'm the first one to admit it. So I don't think there's any problem with that. We are trying to get a statute passed for electronic wills, where not only would you go to a website, you would just do it electronically and notarize it and sign it electronically. We're getting pushback from the legislature, so I don't know if that will ever pass. But yeah, people can do these things themselves. But if they got any complexity, they really probably should get some assistance, because you can have results occur that you did not intend.
Okay, one last question. Is there anything I can do to stop my mom from spending all of her money?
Well, it depends. If the decisions that mom is making is because she is legally, because the doctor determines that she does not have capacity to be making those decisions, then you would have to go get a guardianship. I mean, we've had to help clients do that. We have clients who give away all their money to charity, for example. That may not be a rational decision. But if the doctors think that the person has the capacity to make the decisions and that these are not imprudent or irrational, they can be imprudent, but they can't be irrational decisions. And then they're free to do that. So the only recourse you have is to go to court and have a court declare your mom incapacitated and take control of her finances. But if she's not incapacitated, then she can continue to spend her money foolishly. We are allowed to make bad decisions in life.
I think we talked about that our first week about our elders and reframing, and as a caregiver, having to be able to let your parents make bad decisions, you know?
Yeah, and there's I referenced that ACTEC Foundation website. On there it's a much longer talk, but there's a wonderful presentation by Professor Mary Radcliffe on basically, can grandma gamble? When do you step in? When do you say grandma shouldn't be going to the casino? And when do you take away somebody? Because when you get a guardianship, you're taking away legal rights. And so that's why the court has to say that the person, due to whatever condition it might be, is unable to make decisions or are causing harm to themselves, before they can take away somebody's rights to spend their money the way they want to spend it. For people that work with seniors, I have to talk to families all the time about this, right? And I want them to listen to that talk, because it's really interesting and thought-provoking about where do we draw the line to where we're taking away somebody's freedom to make what we think might be a bad decision, but it is their money. And there's lots of considerations in all of that. So
I think we have time for one more. If a person has no one to be their own POA for medical, can they be their own on their AHCD?
Okay, well, I don't understand. I think I understand the question.
Oh, they're saying poor Sam.
Yeah, but because here's the thing. You don't need an advanced healthcare directive if for yourself. You can always make your own decisions. Always. So
Okay.
if that's what the question is, no, you don't appoint yourself to make your own decisions. You communicate those decisions. But what does happen when there is nobody? So we are finding more and more people who may have never married, don't have children, don't have close family, and they don't want to burden their friends. Who do they appoint? So for financial matters, we do have corporate trustees, that we can go to. We can go to, Wells Fargo has a trust company, Peak Trust Company in Anchorage, First National Bank. Those are our three big ones in Alaska. We can go to them and we can say, usually we would use a trust, but would you be the power of attorney? Would you be the trustee? But they're not going to make healthcare decisions. So there is no answer to that question. what would have to happen is if you don't have an advanced healthcare directive and we don't have anybody in that family line under our surrogate statute, the court's going to probably appoint the Office of Public Advocacy to make those decisions on behalf of the person. And that's unfortunate. We do have private guardians and private conservators as well that can possibly be appointed, but mostly it's the Office of Public Advocacy.
So what is the difference between an executor and a trustee?
So an executor is a term we don't use in Alaska. So let me tell you, an executor is also what we call a personal representative in Alaska. They manage an estate under a will. They have to go to court to get their authority. So if I have a will and I have to file it with the court, that's where they get their authority. That's who's an executor or personal representative. A trustee is somebody who is named to manage assets held in this trust document. So if somebody did a revocable trust, they're going to have a trustee. So they are different. And so when we do, special needs trust, that's a trustee. So personal representatives / executors only under a will after somebody dies. A trustee's powers can be during life of the person or after death, depending on how the trust is written.
So it sounds to me like your personal representative here in Alaska should be chosen very carefully. If that's somebody that you need to trust.
Well, that's true. Yes, you do need to trust them. And you also need to be very, very careful in naming your agents under your power of attorney as well, because those are extremely broad powers. And you want it to be somebody that you trust, and you want to make sure that they are aware of it. I just had a case where somebody appointed a personal representative and died and didn't tell that person that it was going to be them. And this was not a family member. So that caused a little heartburn in the family, and it's all been taken care of, but caused some heartburn for a little bit. That could have been avoided had there been a little bit more communication. So choosing the people who take on these roles is very, very, very important. I tell my clients, a lot of people come in and say, I'm just going to choose my oldest child. And I say, is the oldest child the best one to do it though? Right? I was the baby. I would be the best person to do it, right? It's my job, right? But, if my parents went down the line, they wouldn't choose me, So you have to really look and see, do they have the skills? Do they have the aptitude for finances, particularly, do they pay their own bills on time? Imagine paying yours. And are they available? They don't need to be in the same community as you, because we do everything remotely now. But you want to make sure that they're available. And same with the personal representative. They do not need to be in Alaska. They just need to be available.
Wow. Well, thank you, Beth, for everything, for all your time. I think this is going to be amazing. And the really awesome thing about this, Beth, is that now it's a YouTube video.
Great.
And it will also be available on our website once it's uploaded and recorded there. And so if people that are listening, if there was just like too much information at once to write everything down, you can always go back through and listen to the webinar and watch the webinar again. So thank you so much, Beth.
You're very, very welcome.
I think
happy to share the information. I think it's wonderful that you're doing these.
Yeah. So next week will be our last webinar, and Gay Wellman of the Alzheimer Resource Center of Alaska will provide some tools for communicating in ways that work with all members of your caregiving team, including the person living with dementia. So I just want to say again, we're available. The webinar will be next Wednesday from 4 to 5. Also, you can go to our Facebook page. It will be uploaded there shortly if you want to listen to the recorded version. And we look forward to seeing everybody next week. And Beth, thank you so much again.
You're very welcome.
All right. Bye-bye.
Happy holidays to everybody. Bye-bye.
All right. Whew. How do you think it went?
Recording is stopped.